Welcome, and thank you for joining us today for our Land Services SA webinar on how to prepare a certified application for deposit of a plan of division, known as an RTC dealing. This webinar is pre-recorded with a live Q&A session at the end of this presentation. We ask you to kindly hold all your questions until the allocated time, where one of our subject matter experts will be able to assist. Land Services SA is committed to providing an excellent customer experience. One way we continue to deliver value to the industry is through our industry education program, where we produce a range of helpful educational materials, hold regular webinars, and host industry events. Our industry education program addresses key topics or frequently asked questions to ensure you remain up to date with contemporary practices. We want to help set you up for success and believe helping with industry education will help reduce the volume of requisitions, meaning a quicker and more seamless experience for your clients. Land Services SA's subject matter experts assist in delivering our industry education program, utilising their years of experience and respected place in the industry. This webinar was prepared by Jamie Heinrich, who has over 19 years of experience in numerous positions within Land Services SA and has spent the last 2 years in the property examiner role. The broader property examiner team have a broad knowledge base and extensive experience in land titling, and it is very likely that you have dealt with one or all of them at some stage. In this session, we will be covering when to prepare an RTU versus an RTC dealing, relevant plan components, land description, mode of issue, transaction, schedule of easement, and consents and certification. We will also cover key points to remember that will address common errors. Let's begin. To know whether to lodge an RTU or an RTC, you will first need to determine if there are any transactions occurring as a result. You will also need to make sure you have current copies of the plan and relevant title. This table summarizes some of the things that are not considered a transaction and those that are. However, if you lodge an RTC dealing and there are no transactions, the RTC will still be accepted. For more resources, visit the Industry Education Hub on our website. I mentioned earlier that you will need to make sure you have a current copy of the plan. This is important as the plan can change even after it has been approved. Here are some of the things to look out for on the plan that may affect your dealing. Check the purpose. If it shows easement, then there should be a proposed easement that can only be created later with a grant of easement document, and therefore should not be referred to in your dealing. If the purpose includes redesignation of parcels, your dealing will also be affected. You will need to determine which parcel NCT is being redesignated by looking in the annotations panel. I will cover the effect this has on your dealing in more detail later. Also, due to a system constraint, the plan purpose cannot be edited in EPL. Therefore, you will need to check the annotations to see if the purpose is incorrect and what it should be. Check all title references to be included in the land description panel, and specifically check for any part CTs, as this will affect how you show the portion of land in the land description panel, and whether any balance parcels will need to be included in the mode of issue. Check to see if there are any other titles affected. Titles will be included here, for example, when there is a partial or full extinguishment and a dominant title or easement engrossed title exists. This title will need to be included in the land description. Extinguishment notes. Consent is required from the dominant registered proprietors or authority on a consent form that includes the extinguishment of easement pre-printed statement. New service easements are not a transaction and therefore do not need to be included in the transaction panel. No consents are required for the creation of a service easement except for the Section 31 statement that is required for a service easement to Distribution Lessor Corporation. There is an example of this on a later slide. If the new easement is a short or long form easement, then this is a transaction and consent is required from the dominant authority or proprietor if outside of the division, and the easement engrossed title is to be included in the mode of issue if applicable. Proposed easements, as I mentioned earlier, are not a condition of plan deposit. The proposed easement is to be created by a TG at a later date or in series with the RTC. Check the annotations for incorrect plan headings as mentioned earlier and shown here. This annotation is also confirming the proposed easement. Easement E does not form part of this division. There could be a number of other annotations that could also affect your dealing, so always read through them all carefully. In addition to ensuring you have a current copy of the approved plan, it is also important to order current copies of the titles to confirm the spelling of the names of your clients, to see if you will need to lodge a change of name prior to your division document. The same goes for the current registered interest. You cannot just tie up a name in the RTC. A change of name of mortgagee will probably be required. Once you have all of the information necessary, ensure you are using the correct form template. For example, new title instructions should not appear on the outer cover for an RTC. The stamp duty ID is always required for an RTC, even if there are no transactions in the transaction panel, and should be written in the panel provided on the outer cover. Also ensure that the correct fees are provided. The fee calculator can assist you in determining the correct fee once you have determined the number of new title fees payable. I will mention this again later. All title references are to be included in the land description that are shown on the plan from the subject titles and other titles affected. The applicant panel includes only the registered proprietors whose land is being divided. Do not include the registered proprietors of any redesignated parcels or other titles affected, as the registered proprietors of these titles are not applicants. They will not execute the dealing as an applicant and are required to consent on a consent form. As I mentioned previously, it is important to determine from the plan if only portion of a title is being affected. If that is the case, then the portion is to be described in the land description panel like this. The application to the Registrar General should not be edited. This clause should not be struck through, even if there are no transactions. There are a number of things to consider when preparing the mode of issue. Order. Parcels should be in ascending order where possible, and interests must be in ascending order for each group. Allotments are first, then roads, then reserves. and then balance and easement engrossed titles. Groupings. Parcels should be grouped together where the registered proprietor and interest are exactly the same. This will simplify the mode of issue and avoid the chance of inconsistencies or errors. Allotment comprising pieces. Where there are pieces on the plan, ensure these are shown as allotment comprising the pieces as per the pieces schedule shown on the plan, in case there may be more than one allotment comprising pieces. Look out for roads and reserves on the plan, as these must be included in the mode of issue and can sometimes be small and easy to miss on the plan. Ensure any balance parcels are included if the land description is a portion of a CT. Consider if these are to be in their own separate title or combined with one of the new parcels, as this is to be made very clear in the mode of issue and will affect the fee. Include any new easement engrossed titles or any balance easement engrossed titles to issue as a result of an extinguishment or variation. When completing the registered proprietors, ensure you enter the names in full, the address and the mode of holding if there are shares or with no survivorship. Authority names must also be shown in full. For example, SA Water Corp is not acceptable and must be shown as South Australian Water Corporation in full. Council addresses are to be the address as would appear on the title. Easements no longer need to be shown in the mode of issue, as this statement will cover any existing or new easements that are shown on the accompanying plan of division. This will also cover any existing easements on a certificate of title, for example, a balance title to issue. Only the prefix and dealing number is shown in the estates or interests panel in numerical ascending order. The exception is in the case of interests over portion, such as an agreement, in which case over portion is to be shown. In the case of a lease, the portion description is also to be shown where applicable. Where a caveat exists on the title, firstly determine if the caveat is absolute or permissive, as an absolute caveat prevents the registration of the RTC and must be dealt with prior to the RTC. If the caveat is permissive, keep in mind that caveats cannot be adjusted, and so may also need to be shown as over portion. Caveats, however, will automatically not be carried forward over roads and reserves. The mode of issue is essential in determining the number of new title fees, so it is important to ensure all titles to issue are captured here, noting that new title fees do not apply to roads and reserves. The transactions will need to be shown in this panel for assessment of stamp duty payable. When completing the transaction panel, we strongly suggest you keep the statement simple and generic to avoid requisitions. Addresses should not be shown, as this overcomplicates the statement. You should only ever need to show these standard notes in relation to easements, keeping in mind that the use of the word easements includes rights of way and party will rights. The creation of easement statements is not to be shown here if there are only existing, serviced, or proposed easements on the plan. This is only for easements with a status of new on the plan. The variation statement is to be used when the easement status on the plan is vary from and vary to. The extinguishment statement only needs to be shown once, and this will cover the extinguishment of all easements shown as extinguished on the plan. The only exception is when the easement area that is being extinguished is vesting as public road or reserve. In that case, this is not considered a transaction, as the easement is extinguished by operation of the Act, and therefore the statement is not required. There are 3 vesting types, and all vestings need to show who the land has come from and who it is to go to. Vesting of land between the owners of 2 or more titles. There can be vestings between the registered owners on the one title. For example, they can vest their shares between each other, so each owner ends up with a separate allotment. This is called partitioning, and it is to be shown in this format. The mode of holding can also be changed. They can go from tenants in common, or shares, to joint tenants, or vice versa. If more than one person is receiving the vesting of land, then the mode of holding needs to be shown when not joint tenants, including with no survivorship. Keep in mind that you cannot add a third party into an RTC document. The only time you can introduce a third party is if there is an allotment vesting to a minister, the Commissioner of Highways, or South Australian Water Corporation. A consent form is therefore required from the authority that is accepting the vesting of the allotment. Do not show the adjustment of registered interests, such as mortgages here. While they are considered a transaction that requires an RTC to be lodged, the adjustment statement is shown on the consent forms only, and the outcome reflected in the mode of issue. If the adjustment of a registered interest is the only transaction, or there are no transactions, nil is to be shown in the transaction panel. Do not show NA or not applicable. If only service or proposed easements are shown on the plan, then strike through both statements in the schedule of easements. If creating a short form easement in accordance with the plan, then just strike through the long form statement. If creating a long form easement, strike through the short form statement and show the long form wording in full. We have included some hints here to assist you when writing the long form wording. However, we cannot help you when preparing the long form wording or provide examples, as this will be unique to what your client wants. There must be something specific they want that does not meet the exact wording of the short form purpose. It is important to determine whose consent is required. This table provides a summary of who may be required to consent within an RTC dealing. This is where you can see that registered proprietors of other titles affected and redesignated parcels are required to consent on a consent form, as they are not considered applicants. However, if the land is being redesignated, consent is only required where the land is being affected by the creation or variation of an easement. For more resources, visit the Industry Education Hub on our website. I will reiterate now a couple of things which seem to be common requisitions. We strongly recommend the use of the generic statements that are pre-populated on the consent form template, with the view of reducing requisitions and simplifying the form. These should not be deleted or modified. The only editing made should be to strike through the inapplicable. If they are all inapplicable, they can all be struck through, and then nil is to be shown. The registered interest of the land being divided is simply agreeing to the outcomes disclosed on the schedule of mode of issue. Therefore, all details on the schedule of mode of issue must be correct. There is a limited number of circumstances where the generic adjustment statement just cannot be shown. This is when the registered interest, such as a land management agreement or lease, is currently over a portion of the title and is being adjusted but will still remain only over portion. This then needs to be specific enough that we can determine which portion it will remain over. The creation of easement statement is only to be used on the consent form of the registered proprietors and registered interests of land outside of the land being divided, a redesignated parcel, for example. Some examples of when nil is to be shown include when you have one title or more, but the same mortgage is being carried forward over all of the same land. When you have two titles and the same mortgage covers both titles, and a new easement, for example a party wall, is being created between the two new allotments. This is the example of a Section 31 statement that I mentioned earlier. This form will always be required when there is a service easement being created on the plan to Distribution Lessor Corporation. This is for the registration of lease 8890000 against the easement. Client authorization is not applicable to the RTC dealing pursuant to legislation. Therefore, the applicant must execute all RTC dealings, noting again that this is only the applicants that execute the dealing, being the registered proprietors of the land being divided, not the redesignated land or other titles affected. While I cannot go through all executions in great detail, here are a few things to look out for. And be aware that the execution requirements I mention here are also applicable to the consent forms. Executions must include original wet signatures only. Where more than one individual is executing, it should be made clear who is signing by showing the name, for example, next to or beneath the signature. Executions by an individual or power of attorney must be witnessed. Witness details must include an original wet signature, the full name, the address, and the daytime phone number of the witness. Power of attorney executions must include the signature and name of the attorney. It must include a South Australian registered power of attorney number, and where the power of attorney is position-based, the execution must include the applicable position of the attorney as it appears in the power of attorney dealing. For company executions, witnessing is not required. However, executions must be in accordance with Section 127 of the Corporations Act, and this must be stated. If only one person is signing on behalf of a company, then they need to state that they are the sole director and sole secretary. If there is only a sole director and there is no secretary, then please refer to Notice to Lodging Parties number 163 for additional requirements. Certifications are to be shown on each execution page. The RTC dealing requires 3 certifications: the verification of identity, the retaining of evidence, and the certified correct pursuant to any relevant legislation. See Notice to Lodging Parties number 189 for further information. Ensure that all details are completed. This includes the name, capacity, and company name of the certifier. We hope this webinar has provided some assistance when preparing the certified form to deposit a plan of division. For future reference, we have included a summary of key points to consider when drafting these dealings. Land Services SA's website has a range of educational and support materials to assist you in your day-to-day work. Our Industry Education Hub is a good place to start. This can be found by clicking Industry Education Hub on the homepage of LSSA's website. A copy of today's webinar will be published on the Industry Education Hub, together with recordings of previously held webinars. That concludes the recorded webinar section. Thank you for listening. Please remain online for the live Q&A session with our subject matter expert.